You are welcome to my All India Bar Examination, 17th Court 2023. Karibu sana, welcome. And read what I posted on the screen. Anyone can unmute and read. Anyone can unmute and read what I posted on the screen.
Multiple choice questions, sir. Dr. Mohammed Hussain Saheb.
The administrative law multiple choice questions. Is it?
Administrative law, sir. Sorry.
Yes. Let me go to the... It is here. Yes, now let me start my All India Bar Examination, 17th Court 2023. Administrative law, the multiple choice questions. Instead of taking the class on 24th, I am taking the class on 26th at 3:10 p.m. to 4 p.m., but 10 minutes late. Now, let us shoot it. First question. Administrative law is the branch of dash. A. Constitutional law. B. Municipal law. C. Civic law. D. Public law.
Constitutional law, sir.
Yes?
Constitutional law.
No doubt it also deals the constitutional law, but the constitutional law comes under... You have to choose from the option which is appropriate.
Public law.
It is a public law. It is
Yes,
a
sir.
public law is the right question for the first question. Okay? Say yes. Second question. Administrative law is the law relating to the administration. It determines the organization, powers and duties of the administrative authorities according to dash. A. The Indian Institute of Law. B. Ivor Jennings. C. Wade. D. K.C. Davis. The quotations which is given there on the screen, according to whom? Among the ABCD.
Ivor Jennings.
It is Ivor Jennings' definition. So Ivor Jennings is the right answer for the second question. Now third question. Administrative law is a judge-made law. It is essentially a judge-made law and it is a branch of public law that deals with the dash and delegation of power. A. Contract. B. Company law. C. Labor law. D. Constitution. Shoot, which is the right answer?
Company law, sir.
No, wrong. Second option.
Constitution.
It is the Constitution. So administrative law is a judge-made law. It is essentially a judge-made law and it is a branch of public law that deals with the Constitution and delegation of power. So the right answer for the third question is D, Constitution. Now the fourth question. Administrative law is primarily concerned with the official action and the procedure by which official action is reached. Example, which one is an odd man out? Means not related to. A. Rule making. B. Rule application. C. Monitoring. D. Mixed administration.
Monitoring is wrong, sir. Monitoring actions is wrong.
No. WRONG.
Rule application.
WRONG.
Mixed administration, sir.
The right, your wrong answer is here to this question is mixed administration. It is not the mixed administration. It is a pure administration. Is it clear?
Yes, sir.
Can you read the fifth question? Unmute and read.
Authorities. Administrative law is derived from the authorities from the constitutional and dash. A. Legal law. B. Legislative law. C. Public law. D. Statutory law.
You have to pick from the option A, B, C, D only. No assumption, no presumptions.
Public law, sir.
WRONG. Second option.
Legislative law. Legislative law.
WRONG.
Statutory law.
It is a statutory law. Administrative law is derived from the authorities, from the constitutional law and statutory law. That is the right answer. Means D is the right answer for the fifth question. Now sixth question. Unmute and read.
Sources of administrative law. Which one is not the source of it? A. Constitution of India. B. Rules of regulations. C. Ordinances. D. Acts and statutes. A. Constitution of India is right answer, sir. Administration
Not
law.
the source of it. Which is one is not the source of it. Constitutional law is the main source.
Yes, sir. Main source. Not the. Ordinances, sir. Ordinances.
Ordinance also the main source.
Acts and statutes.
WRONG. I said not. Here,
Then, sir, rules and regulations.
the right answer. Rules and regulations. There are rules are separate, rules and circular are separate. So you have to choose from the options only. No assumption, no presumption. So B is wrong. Rules are different. Here the feedback I have given. Rules. It is defined under the General Clause Act 1897. It is a rule made in exercise of powers conferred by any enactment. It may be applicable to a particular individuals or general public. Regulations and circulars. So it signifies the decisions, orders, and acts of the government are made known to public in the sphere of the administrative lawmaking. It means it is related to the situations where power is given to fix the date for the enforcement of an act. This can also be related to the exemption from the rate fixing and prices. So regulations and circulars are there. Ordinances are there. And here I made rules and regulations. So rules and regulations is not related. Rules are there and regulation and circulars are there. So you have to choose from the A, B, C, D. The wrong answer is rules and regulations. Is it clear?
Sir.
Good. Next. Seventh question. Ordinances. When the parliament is not in session, the executive branch under Article Dash is given the permission to make the ordinances. Option A, 213 and 123 article. Option B, Article 123 and 221. Option C, Article 123 and Article 213. Option D, Article 123 and Article 213. I think
Option C is right answer. Article 123 and
I made a mistake here. I should change it. I should say 132. Okay. Now you pick out.
C is right answer, sir.
C is the right answer.
123 and 213.
Yeah, C is the right answer. It is Article 123 and Article 213 is given the permission to make the ordinances. So that is the right answer. C is the right answer here. So eighth question. The landmark judgment such as and find out the mismatch. I said mismatch. Puttuswamy case related to the rights. Menaka Gandhi and Union of India related to the travel abroad. Vishaka and state of Rajasthan related to the prevention of sexual harassment of women at workplace. And PUCL versus Union of India related to the privacy. You say mismatch. And here I have given the mismatch options. A, 1 plus 2. B, 1 plus 3. C, 1 plus 4. D, 1 plus 3.
1 plus 4 is right answer. B.
Right answer is 1
1
plus
plus
4
4 is
is
right
right
answer.
answer. Mismatch. Because
Mismatch.
Puttaswamy case related to the privacy and PUCL and Union of India related to the rights. But the Menaka Gandhi right related to the travel abroad and importing of the passport and the fair trial also, that is. And Vishaka is right because it related to the prevention of the sexual harassment of the women at workplace. So answer for this question is 1 plus 4 is the right answer. See, I have given the Puttaswamy here the feedback. Is it clear?
Yes, sir.
Yes, now ninth question. Which one is the correct statement? And here A, I read it because it's a lengthy one. A, the relationship between the administrative law is not clearly marked out, but the fact remains that the two are overlapping in several aspects. There exists a relationship that is the fundamental in that if one were to represent the two branches of the law in Venn diagrams, then both would have common area known as the waterfall area in administrative law. And B, the relationship between administrative law is not clearly marked out, but the fact remains the two are overlapping in several aspects. There exists a relationship that is fundamental in that if one were to represent to the three branches of law in Venn diagram, the both would have a common area known as the watershed area in administrative law. And C, the relationship between administrative law is not clearly marked out, but the fact remains that the two are overlapping in several aspects. There exists a relationship that is a fundamental in that if one were to represent the two branches of law in Venn diagram, then both would have a common area known as watershed area in administrative law. And the last option is D. And D option goes in this manner. The relationship between the administrative law is not clearly marked out, but the fact remains that there are overlapping in several aspects. There exists a relationship that is fundamental in that if one were to represent the two branches of law in Venn diagram, then both would have a common area known as the watershed area in administrative law. So among the A, B, C, D option, which one the statement is the correct statement?
D is correct answer, sir.
D for Delhi.
Delhi, correct, sir.
Wrong. Second option,
Option B, sir.
WRONG, wrong.
C, sir.
C is the correct statement. I can show you why C is the correct statement. See, the relationship between the administrative law is not clearly marked. And if you happen to see instead of watershed, I wrote the waterfall area. See, instead of in the A, I wrote as the waterfall area. It is not waterfall area. It is a watershed area. Is it clear? Say yes.
Yes, sir.
Okay, now B. Where is the wrong in the B? Can you make it out? Where is the wrong in the B? See, if you see, instead of 2 branches, I wrote the 3 branches of law. Where? Here. 3 branches of law, I wrote here. Instead
Yes,
of
sir.
2
branches.
branches. Is it
Branches.
clear?
It's a
Say yes.
Yes, sir. 2 branches are there.
And
In
what
D,
about the
2
wrong in the
branches are there.
D? What's the wrong in the D? If you happen to see, instead of there are 2
Here except
are overlapping, I wrote there are overlapping.
3 are
Here,
above.
there is no 2. See here.
Yes, sir.
Excuse me. So there are
There are
overlapping, but I removed the 2, but there are overlapping as said. So hence D also the wrong answer. So
Yes,
the
sir.
right answer is
C.
C. C is the right answer for the 9th question. Is it clear?
Clear, sir.
So that is the and 10th question. Anyone can unmute and read 10th question.
In India, in the watershed, one can include the whole control mechanism provided in the Constitution for the control of the administrative authorities. These include dash Article 226, Article 227, and Article 311. 1. Article 32, Article 136b, 3. Article 300, 4. Article 301.
Option A 1 plus 2.
Option A 1 plus 2, option B 1 plus 2 plus 4, option C 1 plus 2 plus 3, option D 1 plus 2 plus 3 plus 4.
Now you can choose from this option A, B, C, D, which is the appropriate answer.
Sir, come down, sir.
Yeah, because there is Article 32 is there in the watershed. Article 136 also there. Article
Article
300
32
also
Supreme
there.
Court.
But Article 301 is not there. Article
Yes, sir.
301 is not there in the watershed. Because I
32,
will show you that where I made it.
1 plus 3 plus 4.
See, here I have taken from here. See, in India, in the watershed, one can include the whole control mechanism provided in the Constitution for the control of the administrative authorities. These include Article 32, Article 136, Article 226, Article 300, but there is no 301. But there is Article 227 is there, Article 311 is there. Is it clear?
Yes, sir. Yes, sir.
Okay, now I can also frame the another question in this manner. It may include some administrative agency to regulate a particular field, that is Article 263, which creates the Interstate Council. Similarly, we have Article 280, Article 262, Article 315, and Article 324. I may give at least either 14 or 16 article instead of in addition to the 315. So if I give the Article 316 in the option, in addition to the Article 280, Article 262, then you have to pick out which one is the wrong answer. So only these are there. 1, 2, 3 means 280 is there, 262 is there, 315 is there, and 324 is there. I will give all the thing, but I can add one more here. And that one more is
262 added, sir.
yeah.
You added 262.
No.
Articles
I am giving the
262 is wrong.
example. I am giving the example. I have not added till, but I can
Okay.
create what I want to say, I can create the question in that manner also. Is it clear?
Okay.
So now, see, for instance, you say, here the administrative law notes important case laws and reading material. I can frame the questions in this manner. Basic introduction to administrative law. Of course, these are the things which is there, but frame the question, I am going to give you the yes, let me scroll it. Okay, because it has not come totally. Yeah, let me check it here because it has not copied totally. See, the framing of the question, I want to say it. For instance, if you make the administrative law notes, and Indian administrative law, you can say. So, for instance, you take this is the thing which I made it, but it's not copied totally. See, this is actually the administrative law notes. So I can frame the question. Administrative law is the law relating to the administration. Instead of administration, what I do, I give the option one administration, another is management, another is regulations, another is rules. So instead of making the rules, regulation, and management and administration, if the four options are given, then you have to choose the option right is administration. Is it clear? I am giving you the model how a question can be framed.
Yes.
Did you get my point? Did you get my point? Say yes or no.
Yes, sir. Yes, sir.
Yes, sir. See, the doctrine developed by the judiciary. Number one, doctrine of legitimate expectation. Two, doctrine of reasonableness. Three, doctrine of proportionality. And four, doctrine of promissory estoppel. Actually, these are the four doctrines developed by the judiciary. Okay? Now,
Okay, sir.
what I do, I wrote doctrine of legitimate expectation, and there I wrote doctrine of reasonableness. Instead of reasonableness, I can say doctrine of reason instead of reasonableness. Then I write doctrine of proportionality, then I write doctrine of promissory estoppel. So one I committed a mistake here is, instead of writing the reasonableness, I wrote the doctrine of reason. So out of 1, 2, 3, 4, then I can frame the question to you and then say which one is the wrong answer. So there you have to pick up. For instance, you take here how I make the questions. I am showing you, for instance, here I made the question here. See, these are the doctrines. Agreed? And which one is not the relevant doctrine? I give you. So what I do now, I write doctrine of reason. Then I will make it 1, 2, 3, 4. I can make the one option, and this is the second option, not option, statement. This is the third, and this is the fourth. And here I will make the options to you, like A, 1 plus 2, and B, 1 plus 3 plus 4, and C, 1 plus 3 plus 4, and D, 1 plus 2 plus 3 plus 4. Now you have to choose the right answer. Now can you tell me the right answer? What is that?
Sir, B.
Yes? Which is the right answer?
B and C both are same, sir.
Yeah, I didn't know. I
Option
will
B
change
and
it.
C
I will
both are
change it.
same,
Two,
sir.
yes, and now I will change it. Now you
C
tell
is
me.
right answer.
Which is
C
the right
is right
answer
answer.
now? Here, if I frame the
C is
question
right
in that
answer.
manner.
1 plus 3 plus 4 is right answer.
1 plus 3 plus 4 is the right answer. Because, and in the feedback I'll give you, in the feedback, I make you to understand feedback. And actually in the feedback there is a doctrine of, what is that? Doctrine of reasonableness.
Reasonableness.
And here what I wrote it, no, doctrine of reason. So no, I'm showing the technique, how I frame the questions. How I frame the questions, I'm giving the technique to you. See, it takes a lot of time to frame the question because, excuse me, we have to see the reasonability also. Are you following me?
Yes, sir.
So from here I made this doctrine of reasonableness and doctrine of proportionality, doctrine of promissory estoppel, and doctrine of legitimate expectation. I framed the question in that manner. For instance, in the same way, if I go to the another point, like writ jurisdiction of Supreme Court and High Court, and everybody knows what is the writ jurisdiction of Supreme Court and High Court.
Article
Yes.
32 and Article 226, sir.
Yes.
Article
There,
32 in Supreme
yes.
Court, Article
Then,
226 in High
then I
Court.
can ask you, judicial review is the power to court to express upon the constitutionality of legislative act within which the normal jurisdiction to enforce the power refused to find the unconstitutional or void. For instance, I can take this statement. For instance, I'm showing you. I take this statement and I will write here because this is the 11th question and this is the 12th question. And 12th question I write like this. For instance, I paste everything. Judicial review is a power of court. So what I do now, for instance, if I want to make it, I cut it this one. I cut that one. Where is it? Yeah, I cut that one. Then I made in the options. Number one, judicial review. Then I changed the options here. What is the best way to change the option here? Can you make it out? Judicial revision. Okay. Then I say instead of review, I can say judicial view. And one, I keep it as it is because that is the answer. Another is instead of changing the judicial review, I say it is a legal review. It is a legal review. So now I will ask the question. And of course, if you want to make it out, I can make the A directly, and this is the B directly, and this is the C directly. And then I ask you, which is the wrong answer? Yeah, now you tell me. So here I say, which is the wrong option? Yes, now you have to pick out. So among this one, dash is the power of the court to express upon the constitutionality of the legislative act which falls within their normal jurisdiction to enforce, and the power to refuse the enforce like they find to be the unconstitutional and void. Which is the wrong option? Number A,
1 plus
judicial
2
revision.
4.
Number B, judicial view. Number C, judicial review. Number D, legal review.
1 plus 2 plus 4.
Here I did not mention 1 plus 2 plus 3 plus 4, or I did not directly asked. So now what do you shoot? Which is the wrong
Judicial
option?
wrong option.
Not
Legal
wrong
review is
option.
wrong
Not
answer,
wrong
sir.
option. Which is the right option? Yes, now you
Right
tell me.
option. Correct, sir.
Which is the right
Now
option?
judicial review is right answer. Judicial review, C is right answer.
See, it is not so easy to prepare the questions now. It takes a lot of time for me to understand because I want to make you confused by using the terminology. And all terminology looks alike. Are you following me? All the
Yes, sir.
terminologies looks alike. That way I have to make it out. So it takes a lot of time to prepare the question. For instance, if you take the principle of natural justice.
11th question, sir.
Yeah, 11th question I give the answer. No?
11th question answer not yet completed.
Is it? Yeah, 11th question I give the answer. A 1 plus 2, B 1 plus 2 plus 4, C 1 plus 3 plus 4, D 1 plus 2 plus
10th
4.
question, sir. Sorry.
Right answer
10th
is?
answer.
11th question, right answer is?
The clear, sir. 10th question not yet complete, sir. Answer.
Your 10th also you made it clear because I already wrote 301 which is not there.
32
I
also.
made it. When additional I made it, then right option is 1 plus 2 plus
3.
3.
4.
Not 4. 301 is
3.
not there.
1 plus 2 plus 3.
That is the right answer. See, when I frame the question, it takes a lot of time for me to see what is the relevancy, how I can confuse you, what is the near answer to it. So all these things should have to take into the consideration, then you have to frame it. Otherwise, easy framing will not be a good one because you can get it anywhere. Is it clear?
Yes, sir.
So, what is a writ and of course we found it. What is a writ and what is? How many types of the writs are there?
Sir?
How many types of the writs?
5 types, sir.
What are they? Go in the sequence. I want to know the sequence. Yes. How many
Center queue.
writs are there under the Constitution of India?
5 writs are there.
Sequence. I want. Then I will write the wrong sequence. Then you have to give me the answer for that one.
HC. Habeas corpus and certiorari. HC.
Yes. Habeas corpus number 1. Okay.
Certiorari.
Huh?
Certiorari.
No, it is not the right sequence. What is the right sequence? Number 1, I know it's a habeas corpus. Number 2, it is a mandamus. Number 3,
quo warranto.
no, always quo warranto comes last. Prohibition. Next,
certiorari and quo warranto.
Quo warranto.
Headmaster.
So I may ask the question, I can change the sequence. See, this is the right sequence. Suppose you may ask me, sir, how could you know it the right sequence? I will show you the sequence also. If you see the here, you can see the right sequence. For instance, I write here, then I can say, and you will see here. There are 5 types of writs which are issued by the Supreme Court under Article 32, High Court under Article 226 respectively. Number 1, habeas corpus and quo warranto being confined to the specific situations. And certiorari and mandamus are the 2 most commonly sought writs in control of the action of administrative. So, if you want to know the sequence of it, and here the sequence is given. Did you see the sequence? Did you see the sequence? Say yes.
Yes, sir.
So I can frame, see the same sequence is there or not. Let me check it.
Same sequence, sir.
See, habeas corpus, mandamus, prohibition, certiorari, quo warranto, see? So they may ask you the question in this manner also. Am I right?
Right, sir.
I am showing the mechanism to you. See, I can jumble it. I remove here, then I can keep it here. I remove this one, then I keep it there. So I can jumble it, then I can ask which one is the correct sequence. Is it clear?
Yes.
So I am showing you the way how we can make the questions in the multiple choice. That's what I want to share to you. So if you just look at the other point
Sir,
of
please
view.
explain about 5, sir.
Yes.
Please explain about 5. It's
Okay, I will explain. Just a minute. Let me go to the again PowerPoint. Yeah. Here, habeas corpus. See, if any person was detained without due process or without any excuse, then such a person would be bring to the let the body bring before the court. Let the body present. Let the corpus present. That is habeas corpus. If you see the case law, especially in the third case law, I will give you the answer in third case law. What is the third case law? Here, the MLA is going to attend the assembly sessions. What is the name of the case law? It's the Jammu and Kashmir case law.
yes, sir. Minister versus Jammu and
No,
Kashmir.
not minister. His name is there.
Sir?
His name is there. See, one case law is state liability, Ruplal versus Union of India. And in this case law, his name is there. Especially name is there. What is the name? Could you know it? I will show you that. What is his name also. Suppose if I don't know the name, let us bridge me. Bhim Singh versus State of Jammu and Kashmir. This is a case law. It's a habeas corpus case law. So in this case law, they said, in the case Sri Bhim Singh versus State of Jammu and Kashmir, the petitioner Sri Bhim Singh was deprived of his legal right. He was illegally arrested and detained, therefore preventing him from attending the assembly sessions, that depriving his constitutional right. And he brought the case, he filed the case habeas corpus. Either he himself or on behalf of him, somebody will file the case in the habeas corpus. Let the body would be present. Of course, they released him, but still he said, my fundamental rights are violated, hence the state should have to pay the exemplary damages, rupees 50,000 is awarded to him in this case now.
Okay, sir.
So that is mandamus. What is mandamus? It's an order, by order.
By order.
By order.
The government implies.
Yes. So how it can be done by order? If any government institutions will not comply or give the reason why you did not issue my license, you have to give the reason. Mandamus means you have to give the reason why. I will show you the here. He is the mandamus. Judicial writ issued as a command to inferior court or ordering a person to perform a public or statutory duty. If you applied for the RTA, for the license, if he did not issue it without showing the reason, you can ask for the mandamus. So a reason should be shown within a stipulated date, either to the lower court or to a person performing a public or statutory duty. Is it clear?
Okay, sir.
So that is the weak command, Latin, is issued by the courts of superior jurisdiction to compel the performance of the specific act refused by a lower court, such as the hearing of case falling within the later authority or a public authority who is working on the statutory duty. So that is the second one what we say. And the prohibition completely prohibit to do a particular thing. For instance, if a lower court without the jurisdiction or by filing any other means, the higher court will give the prohibition order not to proceed. So, not to proceed, they can give it. For instance, I will show you that here. Prohibition, how it can be. Paste, prohibition means. So, prohibition, the action for forbidding something, especially by the law, or prevention by law of the manufacture and sale of alcohol, especially in any area, they will prohibit it. Example of the prohibition I will show you. Prohibition is the act of forbidding or outlining something. When my mom placed a prohibition on watching TV during the dinner, so naturally the prohibition can also refer to one of the most famous act of the prohibition. Of course, here father and mother they will make it out, but the court will make the prohibition. How? A liquor shop is not in the vicinity of the school premises. If any liquor shop permission is given over there, then you can go to the approach to the court, make the prohibition order, remove the liquor shop from the vicinity of the school premises, and you should be far away from the certain area. Not only the school, even for the church, even for the temple, even for the masjid. Is it clear?
Okay, sir. Clear.
So that is the prohibition, we can make it out. Now certiorari. How we can make a certiorari? To whom it will be given? See, the court will give the direction to the lower court to bring the record for examination, whether it is properly following or not. So let me see a writ or order by which a higher court reviews our case tried in the lower court. They will make it out. And if it is not properly made, they will ask the record to bring to the higher court and resolve the issue. So that is the certiorari. A writ or order by which a higher court reviews a case tried in the lower court, ask for the lower court to bring the records and they can proceed. So that is the writ of certiorari. Is it clear?
Yes, sir.
Now, next one is, it is quo warranto. The quo warranto means, suppose if a person without a qualification working in a public office, then we can challenge him a quo warranto. In what authority that you are continuing when you don't have the basic means? Am I correct or not? Let us see. By what warrant? By what warrant authority? A writ of quo warranto is a common law remedy which is used to challenge the person's right to hold public or corporate office. A state may also use a quo warranto action to revoke a corporation charter. If any person is appointed without a basic qualification, of course, promotion is different. At that instance, we can ask for the quo warranto. And what authority that you are continuing there? Is it clear?
Yes, sir.
So these are the 5 writs we can approach directly to the High Court or to the Supreme Court. But there may be some provision also there in the Civil Criminal Procedure Act, we can approach it. Let me see. Can we approach civil court instead of approaching to the High Court or Supreme Court? certain things we need not to go to the High Court and Supreme Court, because even a local remedies you have to exhaust it. Is there no? Under the what circumstances citizen can directly approach the Supreme Court? No. In the court, basic civil procedure rules are there. Yes, you can go for the first alternative remedy and you exhaust the local remedy, and when you are not happy by the local remedy, at that time you can approach to the either High Court or to the Supreme Court. So what are you required to bring is the court on the day of the hearing. So normally you are required to appear in the court with your witnesses. The original copies of the document must be there. And now I want to show you that they say first you can approach the local remedy, and you are not happy by the local remedy, then you can directly approach to the High Court or the Supreme Court. But in general, no, it takes its time, so that directly the people will file a case in the High Court if any fundamental rights are violated by the public authorities. So that is the generally the procedure to be followed. But other things you have to approach to a district court or any competent court to resolve the issue is concerned. Like that, what happens of a pre-trial conference within 14 days under the close of the pleading, the plaintiff is expected to apply to the judge to issue a pre-trial conference notice. Of course, he has given how we can approach to it. But in general, the court say exhaust the local remedies, then you come to the High Court or Supreme Court. But in certain places, fundamental rights are violated over there, then we can directly go to the High Court or the Supreme Court for getting the remedy. So those are the things are there where we can make it out. So if a person is approached, for instance, you say Srimati Ujjambai versus State of Uttar Pradesh, in this case law, how it can be dealt. I'll show you the case law because it is there in the net under the indiaqanun.org. So this is the Srimati Ujjambai versus State of UP is a Supreme Court case law. And here the judgment is, the following judgment were delivered by the S.K. Das. The facts of the case have been stated in the judgment. My learned brother Kapoor J, and it's not necessary for me to restate them. And I have reached the same conclusion as been reached by my learned brother. But in view of the importance of the question I raised, I would like to state in my own words and reason for reaching that conclusion. So they may differ it in the lower court. That's why they will come to the High Court for getting the redressal. And what the repugnant is then, two questions which have been referred to this land bench is that in order for the assessment by any authority under the taxing statutes, which is intra-virus open to the challenge as a repugnant to the Article 19(1)(g), that is on the sole ground that it is based on misconstruction of the provision of the Act or of the notification issued there under. So they challenged under it the Article 19(1)(g), for the tax law is concerned under the Article 32. So he approached to directly the Supreme Court because his Article 19(1)(g) is infringed over there. With that view, he approached the court. I don't know what the court has given the decision here is. The accordance with the judgment of the majority, the writ petition number 79 of the 1959 is dismissed. But the parties will bear their own cost. The restoration of the civil appeal of 1960 is also dismissed, but the parties will bear their own cost. So, if any tax rules are framed over there, if it is not in contravention with the Article 19(1)(g), then it will be continued and the writ will be dismissed. If Article 19(1)(g) is infringed over there, then any tax law article would becomes null and void. So that is the whole idea behind where the people directly approach to the Supreme Court or the High Court instead of going to the lower court, because the lower court takes its own time. But when you want the ready-made answer or the spot answer, you have to approach when the fundamental rights are deprived or infringed. You can approach under Article 226 to the High Court and under Article 32 to the Supreme Court. Is it clear?
Yes, sir.
So that's why we can frame the questions, and in addition to that, I already told you that I framed the questions many under the administrative law in my previous YouTube.
Sir, any other questions, administrative law, please send, sir.
See, I don't copy and paste it. I prepare my own, then I will make you see. Here, administrative law is here. There are, you could see in my video clip also some of them. Earlier, see, this is the multiple choice questions in administrative law. I don't know whether you have such a sharing. I will share it, then I will show you that how it can be there, so that you could listen it also. Could you hear the sound now? Are you hearing that sound? Participants,
Sir,
Good evening to everybody.
are you
All
hearing
India
the sound?
Bar Examination aspirants, the cohort
Say, are you hearing?
17-2022.
hearing, sir.
Can anyone unmute and read what I posted on the screen? Can anyone unmute and read what I posted on the screen?
Number 3, the body of law governing administrative agency. 4th, the body of law governing administrative agencies.
Which option is correct among the four? 1, 2, 3, 4. I quote, the body of rule governing the administrative agency, I unquote. Second option, I quote, the body of law governed administrative agency, I unquote. Third, I quote, the body of law governing administrative agency, I unquote. Fourth, I quote, the body of law governing administrative agency, I unquote. Even though it is wrong, doesn't matter, make a hunch. Sir, we are tafuta. We are searching in the smartphone. Don't do like that. If you do like that, you are deceiving yourself. What is the right answer?
Option 4, sir.
Anyone?
Yes.
Answer is the body of law governing the administrative agency. That is the fourth. The fourth option is the correct option. Administrative law is defined as the body of law governing the administrative agencies. The fourth option is the correct answer for the first question. The second question, who enacts statute? Number 1, legislative. Number 2, parliament. Number 3, state. Number 4, all of them.
All of them, sir.
All of them, sir.
It is a easy question. That's why everybody gave the answer. I want to twist it actually. Actually, I would like to say something. Peoples of the state, but peoples of the state also responsible for the man enacting the law. It is there. So I did not write that option. I said, okay, let me make it easy. At least say whether the people could understand it or not, whether they are wise enough or not, whether they are following my technique or not, whether following my logic or not. I would like to see it. That's why I put that one. Okay, third question. Administrative agencies dash regulations under the authority granted to them by either constitutional provisions or statutes. Find out the correct sequence. Number 1, adapt, repeal, amend. Number 2, adapt, amend, repeal. Number 3, adapt, amend and repeal. 4, amend, adapt and repeal.
I think third one, sir. Adopt, amend, and repeat. I think.
The right answer
Third
is third one. You are right. Adapt, amend, and repeal. That is the right sequence. You are right. Fourth question. Yes, anyone can unmute and read?
Fourth question. The administrative law judge renders a decision called dash one is not connected or odd man out or false one. Number one, an administrative order. Two, which may not be reviewed. Three, by a higher level within the agency. Four, or by a court.
I think which may not be reviewed. sir.
Yes, yes. Not
Only the
it should not be there. This is the, because I put the not to give a confusion to you. So an administrative order which may be reviewed by a higher level within the agency or by a court. So the right answer for the odd man out for the fourth question is second option. Is it clear? Say yes.
Yes.
Yes, sir.
Very good. The fifth question. Administrative agencies are created by dash. One is false and three are correct. Number one, government to administer particular legislation. Two, such as the Social Security Act. Three, Workman Compensation Act. Fourth, Fatal Accident Act.
Fatal Accident Act is wrong, sir.
The three
First one,
is
sir.
correct. Yes?
First one.
No, first one is correct answer.
Okay.
Fatal Accident is wrong, sir.
Very sure, sir.
4.
First one is the correct answer. By a government to administer a particular legislation, such as the Social Security Act, second, third, Workman Compensation Act, fourth, Fatal Accident Act. One is not related to it. A bit
Fatal
of
Accident Act is not.
until you have the very background of it. Yes, the right answer is Fatal Accident Act is not there, but Workman's Compensation Act is there, and Social Security Act is there, and the government to administer the particular legislation is there. So fourth is the answer for the fifth question, which is not connected. Okay, say yes. Can I proceed?
Yes, sir.
Say yes.
Yes, sir. Yes, sir.
Can I proceed?
Proceed, sir.
Yes, sir.
Say yes.
Yes, sir.
Yes, yes, sir.
Taking so much time to give the answer. Sixth question. The main purpose of administrative law consists of, number one, I think I have to forgotten to write there, which is not related to it. False. One is false. The main purpose of administrative law consists of, number one, ensuring the accountability for the administrative agency. Number two, by providing for the judicial review of agency actions. Number three, this body of law motivates the power of the exclusive branch. And the fourth one is provide transparency to the public. I think one is not connected to it. One is not connected to it. Means one is false.
Judicial review is not connected, sir. I think. B. Second one. By providing judicial review of agency action.
See, feedback I have given. Check the feedback. This body of law curbs, I say motivates. Did you get my point here? See, this is, I wrote motivate, but actually it is curbs, not motivate. So the right answer is
Third one.
third one.
Fourth,
For
sir.
the sixth question. So that is the next question. Anyone can unmute and read?
Administrative agencies can be categorized into
Administrative
3.
Agencies
Correct one.
can be categorized into 3.
Okay.
Indicate correct one. The legislative, the executive, and judiciary. The legislative, executive, the judiciary. Executive, legislation, and the judiciary. The legislation, the executive, and the judiciary.
1 is right answer, sir. The legislation, the
The four, one, two,
executive,
three
and
is
the judiciary. First one is right.
I think third one, sir. Executive, legislation, and no. Legislative.
No. First legislation will come, then
Second
executive,
one, sir.
One, sir. One number.
then judiciary. One number is right, sir.
Check it once again.
Option 1 is correct, sir.
Legislative.
Option 1.
See,
Legislative, judicial, executive. Legislative.
number 1 is correct. Number 4 is correct. See. Are you following me? Number 1 is correct and number 4 is correct. I made the mistake here. I actually want to remove something there. I did not remove it. So the answer is
1 and 4.
1 and 4.
actually I want to change something in the 1, but I could not change it, I believe. I thought I changed it, but doesn't matter. At least you know now the correct sequence. Okay, next the fourth question. Eighth question, because my time is so much today, shortage of time mine. So I could not remember it because I taught here the Moshi, the legal research for 2 hours. Okay, administrative law deals with dash. Which one is false? Number 1, the authority's power. Number 2, the manner in which these powers are exercised. Number 3, and the remedies accessible to the aggrieved individuals. Number 4, when these authorities use these powers. Actually, I have shown the feedback. I don't know how many people could remember it. Okay, I mean the 4 options, which is the correct option?
3 is correct answer, sir. False. 3 is false.
Parshuram,
Sir.
from your side, I'm getting the sound. When you want to speak, you can mute it, unmute it. When you don't want to speak, you can mute it.
The third one, sir. The remedies accessible to the aggrieved individuals.
See, when these authorities abuse these powers, but what I wrote? These authorities use the powers.
Abuse.
Which is the right answer?
4.
Option 4, sir.
Feedback. When these authorities abuse the powers, these powers. But I wrote that the 4th option is when these authorities use these powers. So which is the right answer?
Use. Abuse.
4th, sir.
4th one is right answer.
1 is the
4th, sir.
answer for the 8th question. Next, question number 9. Read. Question number 9. Read.
Administrative law is a part of dash. 1. Evidence law.
Question
2.
number
State
9.
law. 3.
Read.
Constitutional law. 4. Central law.
9th question. Administrative law is a part of a dash. Evidence law, state law, constitutional law, central law. Constitutional law, sir. Answer.
Answer is the constitutional law. 3rd is the answer. Next question. That is the 10th question. Anyone can unmute and read 10th question.
10th question, sir. All administrative law concerns are also dash concerns. Administrative law, option 1. Option 2, constitutional law. 3, tort law. 4, civil law.
Administrative law is right answer, sir.
No.
Option 1.
All administrative.
Option 2.
Answer 2. All administrative law concerns are also constitutional law concern. So administrative law is a part of the constitutional law. Next question is 11th question. I will read the 11th question. The primary aim of the study of administrative law is to dash how it is possible to keep these administrative authorities within their limits so that discretionary powers cannot be transferred into the arbitrary powers. Number 1, ravel. Number 2, unravel. Number 3, tie. Number 4, untie. In this dash, which is the appropriate word?
3. Tie.
Unravel. Number 2.
Unravel is the appropriate word. Unravel is the appropriate word. Okay, now let us see this. A bit I jumbled it. The role of administrative law is to dash. Which one is being correct? Number A, unlimited government agencies. B, power. And C, to unkeep administrative authorities. D, in check. Number 1 option, A and C. Number 2, A and C. 3, B and C. 4, B and D.
Sir, 4, sir, B and D.
B and D is the right answer. There is no unlimited. There is a limited government agencies and there is no unkeep. There is a to upkeep. That is to keep administrative authorities. That is the wording should be there. In the feedback here, you can see the role of administrative law is to limit the government agency powers and to keep administrative authorities in check. So that would be the answer. In the sense, for the question 12th, the answer is 4. And question number 13. Yes, anyone? No, I will read it. Which one is the correct statement? Statement is correct. Number 1, administrative act should act as the proper law governing administrative action. Number 2, administrative law should do as the proper law governing administrative actions. Number 3, administrative law should act as the proper law governing administrative actions. Number 4, administrative law should act as the improper law governing the administrative action. There are
Number 3.
Number 3 is the right answer. Administrative law should act as the proper law governing the administrative action. That is a very correct answer. Other two, I made the mistakes here and there, and that's why they are the false. Yes, anyone can unmute and read the question number 14. सारे जहां से अच्छा हिंदुस्तान हमारा, जय हिंद।
ख्वाब तो सिर्फ कश्मीर की आज़ादी के आते हैं।